Hello and welcome to Unjustified, where we always cover the truth, the facts, the good, the bad, the ugly, on an unbiased and sometimes very unpopular opinion. This motion was actually filed on August the 19th at 9:58 p.m. This is an objection to requests for expanded media coverage filed by the Associated Press. Christopher Watts, by and through counsel, informs this court that he objects to the request for expanded media coverage filed by the Associated Press. As grounds, therefore, Mr. Watts states: 1. Mr. Watts is set for a hearing on August the 21st, 2018. Media coverage of court proceedings is governed by Colorado Supreme Court Rules, Chapter 38, Rule 3, Media Coverage of Court Proceedings. The rule places limitations on expanded media coverage, stating that there shall be no expanded media coverage or pretrial hearings in criminal cases except advisements and arraignments. The rule does not specifically allow for expanded media coverage for advisements and arraignments, but rather gives the court factors to be considered if there is such a request. Pursuant to Rule 3, in determining whether expanded media coverage should be permitted, a judge shall consider the following factors: A. Whether there is reasonable likelihood that expanded media coverage would interfere with the rights of the parties to a fair trial. Whether there is a reasonable likelihood that expanded media coverage would unduly detract from the solemnity, decorum, and dignity of the court, and C. Whether expanded media coverage would create adverse effects which would be greater than those caused by traditional media coverage. Expanded media coverage would interfere with Mr. Watts's right to a fair trial. Expanded media coverage would unduly detract from the solemnity, decorum, and dignity of the court. Expanded media coverage would create adverse effects that would be greater than those caused by traditional media coverage. Mr. Watts is not objecting to traditional media coverage. Expanded media coverage would prejudice Mr. Watts in the following ways. Photographs of Mr. Watts in custody, handcuffed, and in protective clothing are inherently prejudicial and unnecessary. This court has previously allowed for such photographs, allowing additional coverage of Mr. Watts in custody, handcuffed, and in protective clothing will only continue to prejudice Mr. Watts from having a fair trial. There has already been substantial media coverage in Mr. Watts's case. This unusual amount of information has the potential to create additional prejudice against Mr. Watts and to violate his legal rights in this case under both the Colorado and United States Constitution. Wherefore, Mr. Watts moves this court to deny the Associated Press's request for expanded media coverage, and it is signed off by John Walsh, Megan Ring, Colorado State Public Defenders. Okay, this one was also filed at the same exact time, August the 19th, 9:58 p.m. But this one is filed to KMGH, which is another media outlet. It says the exact same wording as the one before that we did just read. Okay, and again, this one as well, August the 19th, 9:58 p.m. Exact same motion, but this one is filed by the Denver Post. Exact same wording, exact same motion, just to a different outlet. Again, exact motion, different outlet, and filed exact same time, August the 19th. But this one is filed by the COLORADOAN. Same wording, same motion. Okay, this one is out of order, but it was filed on August the 16th at 2:23 p.m. by Michael Rourke. People's response to expanded media coverage request. Comes now Michael J. Rourke, District Attorney in the 19th Judicial District, County of Weldon, State of Colorado, and respectfully submits the following response to the numerous requests for expanded media coverage as follows. 3 subsections of the rule must guide the court's decision. Standards for authorized coverage in determining whether expanded media coverage should be permitted, a judge shall consider the following factors. Whether there is a reasonable likelihood that expanded media coverage would interfere with the rights of the party to a fair trial. Whether there is a reasonable likelihood that expanded media coverage would unduly detract from the solemnity, I know I'm saying that wrong, decorum and dignity of the court, and whether expanded media coverage would create adverse effects which would be greater than those caused by traditional media coverage. Limitations on expanded media coverage notwithstanding, an authorization to conduct expanded media coverage of a proceeding, there shall be no a. expanded media coverage or pretrial hearings in criminal cases except advisement and arraignments. Expanded media coverage of jury, audio recording or Zoom, close-up photography of bench conferences, audio recording or close-up photography of communications between counsel and client or between co-counsel, expanded media coverage of in-camera hearings, close-up photography of members of the jury, authority to impose restrictions on expanded media coverage. A judge may restrict or limit expanded media coverage as may be necessary to preserve the dignity of the court or to protect the parties, witnesses, or jurors. A judge may terminate or suspend expanded media coverage at any time upon making findings of fact that 1. Rules established under this rule or additional rules imposed by the judge have been violated, or 2. Substantial rights of individual participants or rights to a fair trial will be prejudiced by such coverage if it is allowed to continue. Arguably expands upon this guidance the Court of Appeal constructing Colorado Code of Judicial Contact Temporary Canon upheld the trial court's findings that the presumption was in favor of open coverage and that a party opposing such coverage would have the burden of providing adverse effects therefrom. States explicitly that all parties have a right to be heard, at least in writing, if not in court on record. The state of the law then appears to require granting the request unless a party opposing the request demonstrates a valid reason to rule otherwise. In the absence of any prejudice to the people caused by expanded media coverage, the people make no objection to the request on their own behalf. However, the people can take no position on the remaining extensive analysis required of the court and thus leave the court's discretion a determination as required. The people ask the court to consider this response as apt to all substantially similar requests for expanded media coverage by any entity meeting the definition of media, unless the people affirmatively file a subsequent pleading stating a different position. Dated the 16th day of August, 2018, Respectfully submitted, Michael J. Rourke. This one also was filed August the 16th, 2018 at 8:29 p.m. This is filed by the people of Colorado, Michael J. Rourke. This motion is the people's response to defendant's motion seeking court order mandating defense be present during the autopsy of defendant's murder victims. Now, Michael J. Rourke, District Attorney in and for the 19th Judicial District, County of Weld, State of Colorado, by and through his duly appointed Chief Deputy District Attorney, respectfully requests that this court deny the defendant's request for a court order mandating that the coroner permit defense experts, attorneys, and/or investigators to be present for the autopsy of defendant's murder victims. As grounds, the people state the following. Defendant is charged with 3 counts of first-degree murder and 3 counts of tampering with deceased human body related to the killing of his wife and 2 daughters. The autopsies of each of these victims is scheduled to occur at 10 a.m. on August the 17th, 2018. Defense counsel has indicated in email correspondence that he intends to file a motion later tonight requesting that this court order the coroner to permit defense experts, attorneys, and/or investigators to be present for the autopsies of the victims in this case. The body of defendant's wife was located earlier this morning after being recovered from a shallow grave near an oil tank. Later this afternoon, law enforcement recovered the bodies of the defendant's 2 daughters from inside oil tanks located near the grave of their mother. The Weld County coroner has informed the prosecution that time is of the essence in conducting these autopsies, especially for the children, given the period of time their bodies were submerged in oil. The coroner is an independently appointed governmental official who conducts his operation pursuant to state statute. Undersigned counsel is aware of no authority mandated the inclusion of defense retained experts and/or attorneys at autopsies. The legislator has only provided for the presence of representatives of the defendant in the limited circumstances of destructive testing of evidence. Moreover, the Colorado Supreme Court has also confirmed the principle that a court's supervisory role with respect to the handling of evidence is triggered only in situations involving consumptive or destructive testing. The people respectfully assert that any non-consumptive or non-destructive gathering of evidence should not be subject to oversight or limitations. Though not binding upon this court or directly on point, it is instructive that the County District Court in the James Holmes capital murder case, after considering a somewhat similar motion for the defense, concluded the following. A trial court's role prior to testing is to oversee the preservation of evidence. The authority of the court to supervise the preservation of evidence originates in the court's role to protect the civilized standards of procedure and evidence. Such authority allows courts to avoid or mitigate failure to preserve evidence by prohibiting certain testing or ordering that evidence not be destroyed. However, except in unusual circumstances, a trial court does not have the authority to dictate procedures to a particular laboratory. While the court intends to oversee the preservation of evidence prudently outside of the statutory exception for consumptive or destructive testing, the court finds that it has no statutory authority to order the people to allow defendant a a confidential expert be present during the people's scientific testing. Order Honorable William Blair Sylvester, County District Court. The people respectfully assert that aside from the limitations established in the Colorado Supreme Court, this court should not interfere with the execution of the people's investigation of this case, the matter in which law enforcement gathers evidence so long as it remains within the constitutional boundaries, and it should remain a function of the executive branch and one free of judicial mandates. The people will comply with the requirements of Colorado regarding consumptive or destructive testing. Moreover, the people will make items of evidence available to the defense at a time and place convenient to the defendant so that he can retain his own experts to test the evidence. Finally, it is anticipated the defendant will argue that conducting an autopsy without the presence of defendant's representatives will deprive defendant of a realistic ability to confront and rebut testimony under the Confrontation Clause of the United States Constitution and the Colorado Constitution. However, defendant cannot cite any case law in support of this contention. The people assert that while the defendant has a right at trial to confront the testimony of any pathologist or coroner investigator, defendant does not have a right to have a representative present during the autopsy of the victims. Wherefore, the people ask that this honorable court deny the defendant's motion in its entirety, dated the 16th day of August, 2018. This goes back to the motion that Chris and his defense team had put in that we've already went over about the DNA swabs and of the neck and the hands, and also Shanann's fingernails and fingernail clippings. This was signed off Michael Rourke by Stephen Wren, and as we know and we have talked about several times before this one, this request was indeed denied by Chris. This one was granted by Michael Rourke. Okay, here is another one filed by Michael Rourke. This one was filed on August the 17th, 2018 at 1:17 p.m. This is the people's response to the defendant's motion number 2, the motion to allow confidential defense experts to be present for scientific testing and evidence. So see, these motions for this DNA went back and forth between Rourke and Chris's defense team quite a lot between the 16th and 17th. Chris's defense team continued to file motions to get it granted, that they wanted someone from their team in the autopsy room and to be present during the autopsy. Okay, Michael Rourke continued to rebut those motions with his own motions that there would not be anyone from the defense team present during the autopsies. What ended up happening is Chris and his team, all of their motions were denied by the judge on that particular thing about the autopsies. Michael Rourke's were all granted of him rebutting any of the defense team to be present during the autopsies. Comes now Michael J. Rourke, District Attorney in and for the 19th Judicial District, County of Weld, State of Colorado, by and through his Assistant District Attorney and Chief Deputy District Attorney, respectfully request that this court deny defendant's motion to allow confidential defense experts to be present for scientific testing as evidence as grounds that state. The people state the following. The defendant has requested that this court order that confidential defense experts be present for all scientific testing of evidence in this case. The defendant states that without her own expert present, and that should be his. I have noticed that very many of these motions, instead of saying his, it says her. So, without his own expert present during testing to observe the people's experts' methods and procedures, he will lose any realistic ability to confront the people's evidence as to such testing. For the general proposition that effective assistance of counsel may necessitate the need for the defendant to retain his own experts, the people do not disagree with this general proposition. Defendant, however, provides no authority for the proposition that the inclusion of defense retained experts in non-destructive testing is in any way mandated by statute or case law. To the contrary, the legislator has only provided for the presence of representatives of the defendant in the limited circumstances of destructive testing of evidence. Moreover, the Colorado Supreme Court has upheld the principle that a court's supervisory role with respect to testing of evidence is triggered only in situations involving consumptive or destructive testing. The people respectfully assert that any non-consumptive or non-destructive testing should not be subject to court oversight or limitation. Though not binding upon this court, it is instructive that the County District Court in the James Holmes capital murder case, after considering a very similar motion from the defense, concluded the following. A trial court's role prior to testing is to oversee the preservation of evidence. The authority of the court to supervise the preservation of evidence originates in the court's role to protect the civilized standards of procedure and evidence. Such authority allows courts to avoid or mitigate failure to preserve evidence by prohibiting certain testing or ordering that evidence not be destroyed. However, except in unusual circumstances, a trial court does not have the authority to dictate procedures to a particular laboratory. While the court intends to oversee the preservation of evidence prudently, outside of the statutory exception for consumptive or destructive testing, the court finds that it has no statutory authority to order the people to allow defendant a confidential expert to be present during the people's scientific testing. The people respectfully assert that aside from the limitations and the Colorado Supreme Court, this court should not interfere with the people's investigation of this case. The Colorado Bureau of Investigation is an agency that is already overburdened. If agents were required to stop and coordinate with the defense at every step regarding every piece of evidence to be tested, it is unlikely the people would be able to complete their investigation in a timely manner. The people will comply with the requirements regarding consumptive or destructive testing. Moreover, the people will make items of evidence available to the defense at a time and place convenient to the defendant so that he can retain his own experts to test the evidence. Finally, the defendant argues that scientific testing of any evidence without the presence of defendant's experts will deprive defendant of a realistic ability to confront and rebut testimony under the Confrontation Clause of the United States Constitution and the Colorado Constitution. However, defendant does not cite any case law in support of this contention. While the defendant has a right at trial to confront any state experts involved in scientific testing of evidence, there exists no precedent establishing that the defendant has a right to have a confidential expert present during the people's scientific testing. Wherefore, the people would request that the court deny the defendant's motion number 2, or in the alternative, the people would request a hearing of this matter. Dated the 17th day of August, 2018. Michael Rourke, Steve Wren, and Patrick Roche. Okay, this motion was filed on August the 18th, 2018 at 11:34 a.m. This is the people's response to defendant's motion 3 for a protective order. Comes now Michael J. Rourke, District Attorney in and for the 19th Judicial District of the State of Colorado and by and through his Chief Deputy District Attorney and Deputy District Attorney respectfully responds to defendant's motion 3 for a protective order as follows. The people acknowledge that the defendant does not wish to be interviewed, contacted, or questioned unless his attorney is present. The defendant's motion 3 also requests an order requiring the Office of the District Attorney and other law enforcement personnel to obtain consent from defense counsel before attempting to interview the defendant. While the likelihood of any contact is minimal at best, the people must object to this request to the extent that the defendant himself maintains the right to initiate contact with or without consulting defense counsel. There is no legal right or power to eliminate the defendant's constitutional right in this regard. Furthermore, the defendant may, as a matter of law, be interviewed on an unrelated matter as necessary. The Sixth Amendment right to counsel is offense-specific. It cannot be invoked once for all future prosecutions, for it does not attach until a prosecution is commenced, that is, at or after the initiation of adversary judicial criminal proceedings, whether by way of formal charge, preliminary hearing, indictment, information, or arraignment. The police have an interest in investigating new or additional crimes after an individual is formally charged with one crime. To exclude evidence pertaining to charges as to which the Sixth Amendment right to counsel had not attached at the time of the evidence was obtained, simply because other charges were pending at that time. It would unnecessarily frustrate the public's interest in the investigation of criminal activities. Wherefore, the people would request this court deny the defendant's motion 3, or in the alternative, the people would request a hearing of this matter. Dated on this 18th day of August 2018. Michael Rourke, Steve Wren, and Patrick Roche. Okay, this order or motion was filed August the 18th, 2018 at 11:34 a.m. This is the people's response to the defendant's motion 5 to limit pretrial publicity. Comes now Michael J. Rourke, respectfully responds to the defendant's motion to limit pretrial publicity as follows. The defendant has requested this court an order limiting any potential pretrial publicity, and in support thereof cites to Colorado Rule of Professional Conduct 3.6 and the American Bar Association Standards for Criminal Justice. It is the people's position that no order is necessary, as the parties, both the District Attorney's Office and Defense Counsel, are bound by the Colorado Rules of Professional Conduct with or without a specific court order. The people object to the proposed order attached to the defendant's motion 5, as it represents an unnecessary and unwarranted expansion of the ethical rules adopted by the Colorado Supreme Court. The people recognize that the proposed order is a recitation of the ABA recommended standards. However, these standards have not been confided or adopted by the Colorado Supreme Court and remain mere guidelines for conduct. The people request that this court deny the defendant's motion number 5 and the order attached thereto, and simply require that all parties comply with Rules 3.6 and 3.8 of the Colorado Rules of Professional Conduct. Wherefore, the people would request this court deny the defendant's Motion 5, or in the alternative, the people would request a hearing on this matter prior to a court order being issued. Dated this 18th day of August 2018, Michael Rourke, Steve Wren, and Patrick Roche. This motion was filed August the 18th, 2018 at 11:34 a.m. This is the people's response to the defendant's motion number 7, the motion to preserve and produce paragraphs 1 and 6. Comes now Michael Rourke and respectfully responds to the defendant's motion number 7 as follows. In defendant's motion 7, paragraph 1, defendants request all recording produced or seized in connection with this case. The people would request clarification as this request is overly broad. The people are well aware of their Rule 16 obligations. The people have every intention of providing recordings produced and seized in connection with this case. However, if the defendant is including dictation recordings created by law enforcement in his request for an order, then the people would object. If a dictation recording is made, it is transcribed verbatim by the Records Department into the police report. The people do not believe that these dictation recordings are discoverable under Rule 16. Furthermore, this request is extremely burdensome to not only the District Attorney's Office, but the Records and Evidence Divisions of the Police Department. The discovery of dictation tapes is also redundant, as the written reports are discovered and contain the same information that is on the dictation tapes. The people are respectfully requesting that the court, at this early stage of the proceedings, not order the discovery of dictation tapes until both parties have a full opportunity to litigate whether that discovery is mandated by Rule 16, but rather that the recordings, if any exist, be ordered preserved pending further litigation. Furthermore, in the defendant's motion 7, paragraph 6, the defendant requests all correspondence, including email and text message correspondence by or to law enforcement and the prosecution concerning the investigation of this case. The people object to an order that commands them to discover work product to the defendant. The people are well aware of their Rule 16 obligation and will continue to comply. All correspondence goes well beyond what Rule 16 requires. As an example, a communication may be sent from the district attorney to a detective or other person requested investigative assistance, conferring about trial strategy, or simply setting up a meeting. These types of communication are not police, arrest, crime, or offense reports and are not discoverable. Therefore, the people object to this request to the extent that it exceeds CRIMP 16 and seeks unreasonable, immaterial, and work product items. Wherefore, the people would request this court deny defendant's motion 7, paragraphs 1 and 6, or, in the alternative, the people would request a hearing on this matter prior to a court order being issued. Dated this 18th day of August 2018, Michael Rourke, Steve Wren, and Patrick Roche. Okay, this was filed August the 16th, 2018. This is a motion for an authorization for change in bond. Defendant Christopher Lee Watts. To the Sheriff of Weld County, Colorado. The court has authorized the release of the above-named defendant on bond. The offenses covered by this authority, the amount and type of bail and bond, and the return date to be shown on the bond, as well as any conditions to be typed on the bond or set forth below. In addition, the judicial officer may impose such additional conditions upon the conduct of the defendant as will, in the judicial officer's opinion, render it more likely that the defendant will fulfill all pretrial release conditions. These conditions may include submission of the defendant to the supervision of some qualified person or organization, including pretrial services supervision. The amount of the bail bond, no bond. Type of appearance, and it's just, there's nothing. So he was not issued this bond that he asked for. Okay, and down here, numbers 9 and 11 are checked. Number 9 states you must comply with the mandatory protection order issued by this court. Number 11 states you will not violate any state or federal law or municipal ordinance. Dated August 16th, 2018, the judge or magistrate, Marcelo Copcow, signed off on it. So yes, the motion for him to have a bond was absolutely denied. This is dated August the 16th as well. Even though it's hard to read, it is August the 16th. This is a motion for mandatory protection, and it has Chris's name and birth date and such. And therefore, it is ordered that you, the defendant, 1, shall not harass, molest, intimidate, retaliate against, or tamper with any witnesses to or victim of the acts you are charged with committing. And number 6, it is further ordered that you comply with all bond conditions. And Chris signed off on it, and it is dated 8/16. Okay, this one as well was filed August the 16th at 10:52 a.m. This is a motion to release sealed affidavits in response of the warrantless arrest to Mr. Watts' counsel. Mr. Watts, through counsel, requests that this court unseal the affidavit in support of the warrantless arrest for the defense counsel. There have already been numerous pleadings and orders filed in this case. This court likely need to resolve some of these issues this afternoon. Counsel must have access to this affidavit in order to properly defend Mr. Watts with regard to these issues. In this jurisdiction, it is common practice for defense counsel to receive affidavits in support of warrantless arrest prior to an advisement hearing. Mr. Watts makes this request pursuant to his Sixth Amendment right to counsel, his right to a fair trial, and his right to present a defense, and his right to due process under the Colorado and United States Constitution. And this is signed off James E. Merson, Deputy State Public Defender. This is also dated August the 16th, 8:47. I'm not certain if it's AM or PM. And this is a motion to seal the application and affidavit in support of arrest warrant for Chris Watt. Comes now Michael J. Rourke and respectfully moves his honorable court to enter an order pursuant, sealing application and affidavit in support of arrest warrant for Christopher Watts. The people further request that the court enter an order directing the clerk of the court to refuse access to these documents to all individuals. The following grounds are stated in support of this motion. The information contained in the application and affidavit in support of arrest warrant for Christopher Watts is sensitive to an ongoing investigation. The release of information would jeopardize the ongoing investigation. In that release of the information to the public may hinder further investigation. Release of said documents is therefore not in the public's best interest. Authorizes the court to deny disclosure of any criminal justice records on the grounds that said disclosure would be contrary to the public interest, and specifically authorizes the court to deny access to records of investigations conducted by or of intelligence information or security procedures of any district attorney or police department. Disclosure of these documents would, for the reasons set forth above, be contrary to the public interest. Dated the 16th day of August 2018, Michael J. Rourke, District Attorney by Stephen Wren.